Thank you, Your Honor. Good afternoon, fellow members of the Supreme Court. My name is Kelly Hundley. I'm here on behalf of the City of Dunwoody. The issue before the court is whether the city's occupation tax ordinances, either on their face or in operation, effectively precondition one's ability to practice law in the City of Dunwoody. And I was going to start out by going through the ordinance and show where it doesn't impose any conditions. It really just looks like any other income tax in that you tell the governing entity where you are and where you work. You pay it in arrears after the conclusion of the operational year. There's a grace period to pay it, and if you do pay it, great, and if you don't pay it, then under the ordinance, which is authorized by state law, you can assess a 10% penalty on the delinquency and start assessing interest at that point, but you can't stop Mr. Moss or Mr. Rothenberg from practicing law. But I want to take just a little bit of a different tack and look at the Sexton and the Barnes ordinances and follow up on some of the questioning from Justice Namias. In those cases, if you look at the ordinances in Jonesboro and in Atlanta, those ordinances imposed express conditions that had to be satisfied before the city would even allow you to set up shop and begin to practice law. And if you didn't do that and you set up shop and you started to practice law, they could come in and haul you off to jail and assess a criminal fine. So those ordinances expressly imposed conditions on being able to practice law and backed it up with a punishment that was tied to your practice of law, not because you were delinquent in some respect, but they said if you practice law and you haven't complied, you're at risk of going to jail or paying a criminal fine. And that's not what the City of Dunwoody's ordinances look like at all. And frankly, that's on purpose. Because in Sexton and Barnes, this court held that if you had conditions like that and you had that kind of sanctionable power standing behind it, then you're regulating the practice law. You're putting obstacles in the way of Mr. Moss and Mr. Rothenberg to practice law. You're telling them effectively, you can't practice here unless you do 1, 2, 3, 4, 5. And if you don't do 1, 2, 3, 4, 5, you may find yourself sitting in the clink somewhere. City of Dunwoody ordinance says you got to pay the tax. And if you don't pay the tax, then we're going to issue execution, we're going to levy on assets, because what we're interested in is collecting the tax. You can continue to practice law all you want to. They've continued to practice law. They're here today practicing law. Nobody's threatened to shut them down. Nobody's threatened to take them to the jail. Nobody's threatened any kind of criminal fine. And that's because the ordinances don't provide for any of that. It just says, if you're going to take advantage of the services that the City of Dunwoody provides by setting up shop in the city, then by virtue of state law, we have the right to impose an occupation tax on your business in the city, and that's what we're doing. And if you don't pay it, then we get to do what state law says we're allowed to do to recover the sum due for the tax. You can continue to practice law. Now, I do want to digress for just a moment and address one point that has come up, and it comes up repeatedly, and that's about the comment in Barnes about being able to punish someone for contempt. And I'll admit, I'm not privy to the entire record in that case. So I don't really know exactly what the court was referring to at that point, whether it was referring to the ability of a superior court to cite someone for contempt, or as the case may have been, what they were really doing was referring to a City of Atlanta municipal court. I would agree that a City of Atlanta municipal court, following in the footsteps of Sexton and Barnes, if the city can't penalize you criminally for not paying the tax, then I'm hard-pressed to make an argument why the municipal court could put you in jail for not having paid the tax. But I don't know for sure that that's what the court was referring to in that situation. The superior courts, as you all are abundantly familiar with, have the right to be able to control what goes on in their courtroom. They have the right to impose discipline and sanctions based on what happens in the courtroom, and they have the right to take the steps that they deem necessary in order to implement their orders. If in this case the Superior Court's order directing Mr. Moss and Mr. Rothenberg to pay the tax due, they did not do so, and there was a motion put in front of the judge in the Superior Court to cite these gentlemen for contempt, number one, that's the Superior Court executing its authority over those individuals. It's delegated and has the inherent right to be able to enforce its orders. And in that situation, what we're talking about is a civil contempt penalty, not criminal. So I think that there is far more that is read into what, for me, looks to be more of a cryptic line in the opinion than I think is probably deserved. The bottom line is, if you look at the city's ordinances, there just isn't anything there that gives the city the ability to condition Mr. Moss and Mr. Rothenberg's ability to practice law. They're still free to practice law. They just have to pay a tax on it, and they haven't paid the tax. And we ended up in front of the judge on the original ordinance before it was amended, and the Superior Court judge found that the ordinance was fine. He looked at the amended ordinance and determined that it was fine. And you've seen our briefs and you're hearing the arguments here today. I submit to you that the court was absolutely correct in both counts with regard to the ordinance. I know that Mr. Moss hasn't devoted any time to the other arguments that were raised, but let me just highlight a couple of things. The city doesn't give up its right to complain about what it perceives to be an attorney misconduct simply because it's a city and it has an occupation tax ordinance. If there are attorneys that are doing things that shouldn't be done, laws that apply to them that aren't being followed, I don't know why the city of Dunwoody has supposedly given up its right or has no right to be able to lodge a complaint with the state bar. It's no different in that position than any other person sitting in this room who comes in contact with attorneys. Everybody's got a right to make the complaint to the state bar if they want to. And as the Superior Court judge acknowledged, at that point, it's in the hands of the regulator. The city's ordinances don't give it the authority of investigator, judge, and jury to decide whether or not individuals have violated state bar rules and guidelines. All the ordinance says is we reserve the right to lodge a complaint with the state bar if the occupation tax, a lawful occupation tax, isn't paid. On the issue with regard to equal protection, is kind of dropped as a side note more or less towards the end of their brief. Let me just note for purposes of the record, because I only get to get up here and talk one time. It's a rational basis test. There's an obvious rational relationship between requiring individuals who have decided to avail themselves of the services and the privilege of setting up their business and operating in the city of Dunwoody. The tax goes to defray the expenses for the services that they receive and the services that are available for them if they need them, like police. Finally, Your Honors, with regard to the last two items, the sum that was awarded, there really wasn't much in the way of any opposition at all to the methodology that was utilized and to the computation of the amount, other than to make the argument that a change in the amendment to the ordinance in 2010 relieved Mr. Moss and Mr. Rothenberg of having to pay a 10% penalty for their delinquency for the tax years of 2010 and 11. I've noted in the brief, and I would refer the court to that what the provision in there talks about is that there won't be any criminal penalty assessed against anyone for the practice of law. That has nothing to do with the assessment of a 10% penalty on the delinquency for not having paid the tax on time. They're apples and oranges. They're trains that cross in the night on opposite tracks. We're just not talking about the same thing. Could these ordinances have been drafted a little bit better with the loose language with regard to licensing and occupation tax certificate? The answer to that is yes. There is always room for improvement in the drafting of municipal ordinances. I grant you that. I'm a city attorney myself for another city. I draft ordinances all the time, and I can't tell you how many times after I got through looking at one and it got adopted, I go, geez, I wish I'd have done X. It happens. But the point to keep in mind with regard to these ordinances is, and this is in light of Sexton and Barnes, attorneys are carved out for this special treatment, for special non-regulatory treatment. If the city has the authority to issue a license to some other business, they can impose the requirements on that license, and if they don't comply with it, then that ordinance, which is a self-contained tax ordinance and licensing scheme for those occupations that they can license, then they can impose sanctions. But as you've no doubt seen in the briefs, lawyers are carved out. And lawyers are carved out to be treated for non-regulatory treatment under the ordinance. The city's only interested in one thing with regard to attorneys who practice law in the city of Dunwoody, and that is pay us the tax that's due on your operation. You can practice 7 days a week, 365 days a year. They are not going to keep you from walking in, sitting in your office, and start to work. They just want to make sure that they get paid what their occupation tax ordinance says is due. And so, unless there are any questions, Your Honor, I'm happy to turn the table back over to Mr. Moss.